Our next presentation bears the title, We the Justices of the United States, a Defense of Originalism and Constitutional Interpretation. Please welcome Leslie Kim.
"30 years ago, Ronald Reagan nominated conservative jurist Robert Bork to the Supreme Court. Backlash was immediate, fierce, and lasted for over 3 months. The Senate eventually rejected him by a 58-42 vote, the largest margin of defeat on record for a judicial nominee. His most obvious fault? A long and unabashed history of support for the interpretive theory known as originalism. He was dedicated to interpreting the Constitution by what it meant to the people at the time of ratification, and this produced behind him a trail of uncomfortable rulings, one of which was questioning the desegregation of the South. The failed appointment of Robert Bork set an important precedent in place for today. After his bitter rejection, partisanship is now simply a fact of life in the Supreme Court nomination process. Just this past election season, the race has, arguably, been as much about the empty Supreme Court seat as it has been about the presidency. So why is this? Judges, almost by their very definition, are to be impartial, unbiased, and fair. So how do we explain this caustic battle to appoint judges? The core of the answer lies in what they believe about the Constitution. In 1787, during the Constitutional Convention, one question ruled: how much power could be entrusted to the people? Those who believed unregulated democracy too dangerous instituted an apolitical judicial branch to limit its power and interpret the law. Members of the highest Supreme Court were to be appointed by the president and serve only on the condition of good behavior. Opponents, however, thought that men of such autonomy and power would inevitably overstep their bounds. But for much of the next century, the Supreme Court's rulings generally deferred to the popular majority and legislative branches. For example, the infamous Plessy v. Ferguson case confirmed Louisiana state's separate but equal law in a landmark decision upholding racial segregation. The 1950s, however, brought about the greatest shift in approach. Led by Chief Justice Earl Warren, this Supreme Court became famous for its progressivism, its philosophy of tackling social justice problems neglected by the other branches. The ruling in Brown v. Board of Education banned racial segregation and is still lauded today, but at the time it overturned decades of precedent and framers' provisions for equality. In response, conservatives criticized the court for imposing their personal principles onto the Constitution. They began the call for judicial restraint, or for minimizing one's individual beliefs in favor of impartiality. This newfound scrutiny in understanding the Constitution gave rise to numerous schools of interpretation. On the side of judicial restraint, originalism is the most popular. It holds that the Constitution retains the meaning understood at the time of ratification, or what a reasonable and informed member of the citizenry would have understood it to mean. On the side of judicial activism, non-originalism is the most popular. It posits that the Constitution is a living document which communicates a spirit or set of principles that adapts to changing times. In order to bring about more transparency and consistency to the ruling process, we should adhere to the interpretive theory that best upholds standards of justice and honors the intentions of the founding generation. The originalist method fits best by rightly encouraging a restraint of judicial power. A study of the judicial branch, a study of the intended purpose and structure of the judicial branch, supports the proposition that it was intended to defer to the American people. The originalist approach rightly upholds the Constitution as deriving its authority from the consent of the governed at the time of ratification. It also empowers the citizen-represented legislature to consider our most pressing political and social questions. In the case of any foundational text, it is imperative to consider the historical context. where it came from, whom it was written to, how the people at the time received it. The reason for this is that words change. Without surrounding information, the spoken and written word can, over time, lose its meaning. This logic applies closely to the Constitution. The Constitution is, in essence, the most concise written expression of consent from the American people, and it remains so, crystallized in the meanings of its time until the Democratic Republic decides it should change. Furthermore, investigating the framers' intentions for the judicial branch will give us greater insight on how it should function. The delegates of the convention, both advocates and detractors, believe the judicial branch should lack innate authority, applying but not making the law. Its power was dependent upon the cooperation of the other two branches. That said, an important distinction must be made. We give to the Supreme Court the authority not to determine our standards of justice, but to evaluate cases in light of the standards we have set. In our secular society, it is the job of our community and each person to struggle through, learn, and correct our understanding of justice. It is the job of the court to take the laws we have set, the provisions written in the Constitution, in the cases they review. In the words of jurist and law professor Richard Posner, to find out what is and not what ought to be. Interpreting the Constitution through an originalist lens institutes the proper role of the judiciary. Conversely, originalism minimizes the circumstances where judges extend power beyond their rightful domain. Rulings by the Supreme Court are effectively final, only able to be overturned by formal legislative amendment or subsequent reversal by the court. Because their rulings are later cited as precedent in future cases, justices can and do effectively amend the Constitution. The problem with this lies in the counter-majoritarian difficulty. This argument states, in summary, that justices are not elected by nor representative of the people, and therefore lack the authority to change the Constitution. Our government's separation of powers ensures that no one entity hold a combination of legislative, judicial, or executive powers. Granting the judiciary legislative authority blurs these distinctions and threatens our government's stability. Overstepping legitimate legislative means, even to accomplish a worthy end, damages the integrity of the judicial process. The amendment process is lengthy and comprehensive in order to ensure bipartisan support and bipartisan agreement and a supermajorities of support. History has shown us that good and just amendments can be made. Having a slower, more methodical process of course correction for the judiciary helps us not to err in the extreme. A common criticism of the originalist approach is that we should not be bound to the thoughts of men with problematic moral visions. The framers held views on various issues such as race and gender, which are now generally condemned. We should not, the argument goes, subject ourselves to a framework of justice shaped by such archaic ethics. In a society where we cannot separate ourselves from the past, culture has no way of advancing in social understanding, of improving the situation of the historically oppressed. However, this objection presupposes, rightly or wrongly, that all history can be seen as a wave of advancement. As man grows, learns, and matures throughout society, he works continually to fix the wrongs which have plagued him in the past. By the same logic, we should not assume ourselves free of such societal defects. To the same extent that we are aware of the past moral blind spots, we should recognize our own unknowable faults. If we discard the governmental provisions given by the framers on account of a dimmer moral vision, should we not also expect the same of our posterity? Instead, we should use legitimate means of updating the law, crafting legislation in response to cultural shifts. No scholar and no jurist sets out claiming to be beholden to a liberal or conservative agenda. Their decisions ultimately are extensions and reflections of their judicial philosophy, of the role they perceive the Constitution to hold in their own duties. So while neither side of this argument presents an easy solution, what I've proposed today is that originalism best reveals the truth of how law works throughout society. Originalism should be followed because it upholds standards of justice by honoring the intended meaning of the text and the structure of the judiciary. Indeed, this very stance imparts the reason why we must be invested in this debate. Adherence to originalism clarifies the role of the judiciary and gives legislative power to the people, demanding its citizenry be invested and engaged in the ways they can affect legal and social change. Thank you.